I felt when I was practicing, like the technology I was asked to use on a day-by-day basis was so much different and frankly worse than what I was using on my phone with the iPhone or with Google, and I asked myself, like, why is one of the world's, I'd argue one of the world's most important professions being asked to use technology to do their jobs every single day that felt a decade behind. And I thought maybe I can do something about that.
Today on LawNext, an interview with the founders of Casetext, a legal research service that just celebrated its 5th anniversary in business and whose AI-driven research tool, CARA, last year was named New Product of the Year by the American Association of Law Libraries. This is your host, Bob Ambrogi, and you're listening to LawNext, the weekly podcast that highlights the innovators and entrepreneurs who are driving what's next in the legal industry. And today we're going to be talking with Jake Heller, the founder and CEO of Casetext, and Pablo Arredondo, the co-founder and chief legal research officer.
We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support LawNext. And now, on to this week's interview.
Jake, how are you?
I'm doing awesome, and it's great to be here with you, Bob.
Great to have you. And Pablo, how are you doing today?
Same. Really happy to be here.
So I want to kind of step back. Jake, you were a Stanford Law grad, president of Stanford Law Review. You had clerked for the First Circuit. You worked briefly for, I think, then Mass Governor Deval Patrick, right? Was it Deval Patrick you worked for?
That's right, yeah.
That's right. Is he going to run for president?
No comment.
And then you became an associate at a prestigious law firm, Ropes and Gray. So you were kind of on the path that every law student dreams of reaching, and you walked away to start a legal research company. What the heck were you thinking?
I still don't know. But no, in all seriousness, I loved every aspect of my legal practice. And you're right, I got really lucky with the jobs I was able to have and the opportunities I had in law. There was a piece of me growing up in Silicon Valley and growing up around the birth of the internet and writing code since I was a kid that really loved creating something of value and making something that people really loved. And that was, of all the amazing benefits of working in a litigation career, that was an itch I just could not scratch nearly as well as I could, running a company and building something new. And more to the point, I felt when I was practicing, like the technology I was asked to use on a day-by-day basis was so much different and frankly worse than what I was using on my phone with the iPhone or with Google, and I asked myself, like, why is one of the world's, I'd argue one of the world's most important professions being asked to use technology to do their jobs every single day that felt a decade behind. And I thought maybe I can do something about that.
Well, and more to the point, not just technology, but you focused in on legal research. I mean, what was it that you saw? What was the gap that you saw in legal research that you hoped to fill? What was the problem that you thought you needed to address?
Very briefly, I thought that legal research technology that I was asked to use and that many lawyers were using was both too expensive, but also, so on the one hand, it was out of the reach of many of this country's attorneys to use some of the best technology, but also it was too cumbersome and too inefficient to actually get a good job done quickly. And what I mean by that, and I'm sure Pablo could talk for hours about this concept, but just finding the basic information and not seeing a number of irrelevant documents to what I'm working on right now, using that information effectively, reading and understanding it, and integrating that into your work product was a cumbersome, and it still is a cumbersome and difficult time intensive process. And so on the one hand, I felt like we were paying a lot for not as much value as we possibly could be getting.
So when you originally started this, I think it was May of 2013, actually, that you started Casetext just 5 years ago.
Yeah, that's exactly right.
And you originally were partnering with another lawyer, Joanna Huey, who also happened to have been president of her law review, which happened to be the Harvard Law Review. And Pablo, you came to the company, I think, a few months later. How did that happen? How did you get connected with Casetext?
Right. So actually, I first started talking with Jake closer to May, actually. I had taught myself just enough coding. Jake talks about coding since he was, I think, 12. And I joke, I've been coding since I was 36 years old. So I had taught myself just enough coding to create, I think, a platform you would seen, the wellsettled.com engine. Yeah. And I had sent that to Paul Lomeo, who's the director of the Stanford Law Library, and at the time was. And somebody who's been a real mentor and somebody who's really helped me as I've kind of put my shoulder to this stuff. And he liked it, and he said, you should check out something that another alumni of Stanford is doing, Jake Heller. And so I looked Jake up, and I saw Casetext. I saw some of the really early, this was certainly one of the earliest embodiments of the platform, but I immediately saw that Jake shared my sort of love of building new and better types of legal research tools. And I think I just started bothering him until he told me that I was joining the company.
That's absolutely correct. Right? Pablo called, I think, late May, early June. We had a conversation. He had 10 ideas. And then the next day, another 10 ideas. And it was amazing. Not even as a part of the company, just, you could tell that there were 100 ideas, every week. That, of which like probably 70 are world-class. And we're still today, 5 years later, working through to get all of the best ideas into the product. I like to joke that Pablo's legal tech Steve Jobs, the kind of person who can see a need in the market. Nobody's even asking for it. No lawyer is saying, I really want, nobody was ever asking for an iPad, but Steve Jobs knew we needed it. Pablo's, I think, is kind of similar. He's like, nobody knows they need CARA, but once they see it, they'll get it.
Right. No pressure with that comparison whatsoever.
No pressure.
It's funny. So I was living in LA at the time, and so in the early months of the company, when it was based in Jake's living room, I would actually stay in their guest room. I think a special shout out to Jake's wife Mickey, who allowed me to stay up. I think Tuesday, Wednesday nights, and then I fly back Thursday. Yeah. So it was very much a startup in those early days.
You'd been practicing law before that too, right? Probably.
Yeah. So for me, litigator, or? Yeah, and I think a lot of people make a lot of Jake's first circuit clerkship, but my summer externship at the Northern District of California is also, I thought, quite prestigious. I too had a litigation career, not quite the stratosphere of Jake's, but I was a patent litigator at Kirkland & Ellis. And to get to your question about sort of what was wrong, for me, when I would be working on biotechnology patent cases, I would run searches, and all the top results were computer science cases. Not because I needed those more, quite the opposite, but because there was more computer science litigation going on. And so those got boosted through the sort of wisdom of the crowd. Those were the ones that everyone talked about. And that was just one of sort of the many, if you will, sort of indignities that a lawyer working in 2005, 6, 7 would suffer really with any technology they touched. It was true of the e-discovery tools at the time and things like that.
So I don't know whether you would consider this a fair characterization, but you just said you've been around for 5 years now, and over the course of those 5 years, you've experimented maybe with a couple of different features that I don't think are part of your platform anymore. You kind of started out with this idea of using crowdsourcing to help annotate cases. At another point, you had launched communities and built a kind of a legal publishing tool around those communities. And so I don't know if it's fair to characterize those as pivots, but I mean, do you feel like you've kind of gone through a process of sort of finding yourself, so to speak, as a company? And if so, do you feel like you're there now?
So it's a great question, Bob. I think that from day one, the core of what we're trying to do has been completely unchanged. And then how we get there is what we have and always will experiment with. So the core is finding a way to build for attorneys everything they need and more, done extremely well at a price you'll love, right? And from day one, we've been trying to build an amazing legal research platform that is executed on, flawlessly, but also doesn't fall into the traps of the kinds of things that cost Westlaw, LexisNexis, and other legal publishers so much to do, and as a consequence, make it so their platforms must necessarily be insanely expensive. And by that I mean, so you talked briefly about some of the things that we've tried in the past, including communities and community-driven content. Much of it lives on, by the way, in different forms. I'm going to talk about that in a second. But when we were trying to do that, the going back to like the big picture we're trying to fix, that was mostly around the cost question. If we were going to be a tool that can be affordable for every single attorney in America, but also be affordable enough for a law firm of the size of, say, Greenberg Traurig or White and Case or Quinn Emanuel to use en masse with all of its attorneys and not have to pass those costs on to clients, then we had to answer the question: how are we to really intelligently get annotated, law, right? Summaries, headnotes, a citator like Shepard's or Keysight. How are we going to do all of that? And everything that we tried with community and with data science and with automation and a number of other things that again, much of this actually does live on through the platform as you see it today, were all experiments, so to speak, for us to answer that big question. Same thing with a lot of legal research functionality. We introduce some things, see that it's actually more useful in one way or another, and reformulate it and put it back on the website. And one thing you can expect from us as a company is that the core is never going to change. We're always going to focus on making a legal research tool that gives an attorney everything they need, doing it extremely well, and doing it at a price that they'll love. But the how we'll get there is going to be influenced greatly by what the evidence and data we gather and our feedback from our users, and what's working, what isn't, and continually improving. And I think you can see one of the things that I think is exciting about running this business, about working here, and about being a customer of Casetext is that we're never going to be static. Westlaw just announced Westlaw Edge, their first major upgrade to the platform in a decade, essentially, maybe 7-8 years since Westlaw Next.
Yep.
That's not us. We're just different. We're gonna improve and improve a lot quicker and be a lot more creative about the things that we try to get to where we need to get to.
So a little more agile.
I believe that, yes.
Yeah. So one of those big improvements in 2016, you launched CARA, which, as I mentioned earlier, last year, the American Association of Law Libraries named it New Product of the Year. And Pablo, I think CARA was, kind of your baby in a way. What do you see? What's the big deal about CARA? Why does it let lawyers? What does it let lawyers do that they couldn't otherwise do?
Well, I think really the power of CARA is the power that comes by harnessing the huge amount of information that is encoded in the litigation record itself, right? Starting with the complaint.
Maybe I should stop you first and say, what is CARA? What does CARA do? And then.
Oh, sure. So, CARA in its first embodiments was a tool that let an attorney drag and drop a brief, and it would data mine the information from the brief, including the case sites, looking at the language, legal phrases and the like, and then would recommend cases that were highly relevant to, but not already cited in the brief itself. So it was a way to take your opponent's brief and within seconds find a bunch of cases that for some reason, even though they were very relevant, the opposing counsel left out. And as soon as we did that, attorneys said, well, what about our drafts? Like, we don't want to file something that's missing a case. And so we added the ability to upload Word documents. And so you would, after a week of using traditional research tools, CARA could often fill in the blind spots of those tools that we're all relying on, basically Boolean and direct citation stuff like Shepard's. So that was sort of that initial embodiment. But underpinning it, I think we always saw that there was something much deeper there, which is once you start to pay attention to the litigation record, not just the briefs, but the pleadings, the complaint and things like that, you have now the ability to tailor the entire search engine to the matter at hand. In other words, those searches that I did when I was at Kirkland & Ellis that made the computer science cases come up would now return biotech cases. Not because I had done a long Boolean query using every word of biotech I could think of, but because the complaints in the case made plain that this was a case concerning, assays of a certain disease or things like that. So fundamentally, what CARA is a new way to think about how to rank and sort and in some ways filter results, where it's not based on what's the most cited, what's the most downloaded, the sort of wisdom of the crowd, but rather what's the best thing for what's the specific matter that you're working on.
I happened to just see you recently at the aforementioned AALL meeting, and we fell into a hallway conversation with Itai Garari, who's the CEO of another legal research service called Judicata, about this question of what is AI in law, and whether, in fact, CARA is AI. You guys describe it as search with AI. Is it AI, and does it really matter what we call it? There's so much discussion around that topic right now. What are your thoughts on that?
Yeah, it reminds me a little bit of somebody who's sort of asking, is something hip hop or not, right? And I guess one level is, look, if people are dancing, does it really matter?
I think to start with the second question you asked first, does it really matter? We are AI, so we'll address that in a second, but does it really matter? No. It's does this really help an attorney find much better information much faster, better cases, better statutes, better regulations, better articles, using a method that was previously thought impossible. Yeah, we do that. And what again, call it hip hop, call it AI, call it what you will. Doesn't matter. It's very useful. But is it AI? I've been working in computer science to at least some degree for now over 2 decades. And AI is not a new concept. It's been something we've been talking about for a very long time. And I think that there are a lot of different definitions of what is AI. I think the best definition is a computer process doing something that was once believed only possible for human cognition, and usually employing certain technologies like natural language processing, image recognition, machine learning, and a host of other technologies. And what does CARA do? It can, in effect, it doesn't actually do this, behind the scenes, but it can, in effect, read a document and then make your entire search smarter, all your entire research experience smarter, based on what you're working on right now, as if some associate was reading an entire brief, pulling out the case citations, thinking about what they mean, what they're like, et cetera. And we're employing the technologies that are commonly associated with AI, like natural language processing, machine learning, et cetera. So I think even under classical definitions, yes, it's AI, but does it really matter? I don't think it really matters. And to be honest, Bob, one of the things that I think is really interesting is that from how we talk about ourselves and how people perceive us, we actually didn't even use the AI term first. A lot of our customers did. And what was interesting about that is it's a 2-letter way of encapsulating in just 2 letters a really big concept, which is this is doing something that it really shouldn't even be possible for a computer to do. And it's really doing something that used to take hours, take seconds or minutes. And I think that when a big law firm or a small law firm talks about why they want to buy AI technology, my belief is what they're really talking about is they want to be more efficient, more effective, to change what they work on so it's less rote and more meaningful. And I think that's really what this kind of AI revolution in law is really about. It's not about the how, it's about how we build this, what technologies we use. It's about, at the end of the day, what you get from that.
And I think Itai, you should definitely have him on to talk about this. We're big fans of his, and I think he's one of the most both brilliant and sincere people in the field. And I think he's pointing at something important, which is that AI is an umbrella term that covers a lot of various things. And sometimes there's a little bit of sleight of hand that happens with some marketing folks, where they'll show you that software they'll show you that software can beat the game of Go using reinforcement learning, and then say QED, therefore AI is going to help understand what argument you should make in your brief, right? And so I think Itai is absolutely right to sort of have folks understand what AI can do and what AI can't, specifically in the context of the things that matter to litigation, for instance, or legal research, which, as Jake alluded to, is much more in the sort of natural language processing area. For me, I'm biased. So I'm not just a fellow at the Stanford Center for Legal Informatics, as is Jake, but it wasn't always called that. Stanford Codex had a big debate internally about whether or not to call it computational law or legal informatics. And I very much championed legal informatics, so I'm very biased here. But I think legal informatics to me is a better term to summarize all of the different things, and because it gets at something important, which is leveraging the nuances of the data in our domain is so important to what we do, right? It's not normal writing to use the phrase, it is well settled hundreds of thousands of times, right, throughout all the documents, right? So I think a lot of what we do is actually, I think best described as legal informatics, although we have certainly seen customers and clients and journalists and things like that sort of sweep it within natural language processing and then sweep that within AI.
We'll get back to my interviews in just a moment. But first, let's take a break to hear from the sponsors who generously support LawNext. And now, let's continue this week's interview.
So, Jake, you alluded earlier to efforts that you've had to develop a citator, and you've recently introduced, I guess, another step in that direction, the ability to identify negative treatments of cases. To talk about how important it is for a legal research service to have an effective citator, and what you're doing to make that happen for Casetext.
Yeah, it's interesting. In the early days, especially with CARA, what we originally saw was that a lot of law firms, like our earliest customers that included like Quinn Emanuel and Ogletree Deakins and White & Case, they weren't using us as their only legal research platform. They're using us alongside tools like Westlaw and LexisNexis, and specifically to get access to CARA's research functionality. And in that context, was it really important that we also have a citator? It definitely helps. So you didn't have to leave the platform to check on Westlaw. Did the case that CARA found me, is it overturned or is it reversed? But it wasn't necessarily absolutely required for them to use and buy the technology. One of the things, and I think Bob, you and I spoke about this recently, one of the things that we've been seeing a lot recently is that there are an increasing number of attorneys who are replacing Westlaw, LexisNexis, Bloomberg, or whatever else they may be using in their practice, oftentimes smaller practices of 1 to 10 or 15 people, with Casetext as an end-to-end, full-on legal research product. And in that context, it becomes way more important to be able to very quickly determine whether or not the case I'm relying on is good law, which is the big role of a citator. The citator essentially says whether first glance, at a glance, in a second, is this case good law? And then secondly, what are the other cases that I should be reading to better understand the case I just read? And it is, I think, a huge accomplishment that we've been able to, in a very short period of time, compared to some of our competitors that have been around since the 1800s, right? To get to a place where we can say with confidence that if a case is bad law, our site will proclaim that very clearly at the top. No, none of these things are perfect. They're, right now on LexisNexis, Miranda is supposedly overturned by a district court case, according to LexisNexis, right? So none of these things are ever perfect. But and I'm sure that everybody using Casetext, along with every other one of these citators, should absolutely look at the house cited list and scan through to see how other cases have talked about it for their own. And that's best practice, again, on LexisNexis, which owns Shepard's, the oldest version of this, or Westlaw with KeyCite. But we have done a lot of tests on this before we released it, and could say, with extreme accuracy in the 99th percentile, that every case that should be overturned or reversed or vacated, et cetera, has that flagged at the very top. And cases that are flagged that way are, in fact, actually overruled, reversed, et cetera, et cetera, et cetera. So what in the field is called high recall, high precision. We feel very proud of what our team of data scientists and some attorney editors to do the things that machine learning can't do, what they've been able to accomplish.
I kind of a follow to that. You probably saw this. I became aware again at this recent AALL annual meeting down in Baltimore of this research paper recently done by 3 law librarians in Connecticut that tried to set out to, I guess, sort of objectively compare 7 different legal research databases, yours among them. It was CaseMaker, FastCase, Lexis, Westlaw, Google Scholar, Casetext, Bloomberg Law. I'll admit I've kind of skimmed their paper without, it's a long and in the weeds kind of a paper. But and I assume you've seen that. But it seemed to be that the sort of the bottom line of it is that some research services do some things better and others do other things better. Does it ever make sense for a lawyer or a legal professional to use just a single legal research service, or should they be planning on having a couple of different platforms that are going to meet different needs they might have? Pablo, what are your thoughts on that?
Well, yeah, I think absolutely. And then I'm thinking here largely about Susan Neville-Mart's work out of Colorado.
But I was going to mention that too.
Right. Yeah, there's definitely been a lot of studies that show this. And I think preferred practice in a perfect world would be to be able to check multiple systems. I think with you, I was joking about having a kayak citator, right? That would just show each service and what they think about whether or not a red flag should be there.
Kayak.com.
Yeah, exactly. Right.
Yeah.
And we'd certainly be willing to participate in that if the good folks at Westlaw and Lexis want to join us in that tool. So, I mean, I think there's also limits, though, realistically, to how much time attorneys have, right? I mean, these motions come on deadlines.
And not everyone's made out of money, right? I mean, that's the other limitation.
Yeah.
If you're at a very big firm, then you may have pooled resources to be able to do that. And in fact, many people who use Casetext at big firms use it maybe 60 or 70% of the time, and then check things in Westlaw or Lexis or somewhere else, that do docket research in Bloomberg or in Docket Alarm. So that's not uncommon. But I think that for the vast majority of attorneys in America, the situation right now is that for most solo and small firm attorneys, they have to pay upwards of $1,500 to $2,000 a year for just a single state's law on Westlaw and LexisNexis, right? So if they're subscribing to one of those platforms, then they can barely afford that, let alone, because I mean, that's a very big expense, comparable with like rent and et cetera, right? Barely afford that, let alone also adding on top of that other research platforms. And what we're seeing is for now hundreds and almost thousands of smaller firm attorneys, they're very interested in are subscribing to our plans that can save them $1,000 a year and use it exclusively, right? So I think the real problem is a resource problem. I agree with Pablo. In a perfect world, with an unlimited amount of time, unlimited amount of money, you should do both, do everything.
Yeah. Along those lines, you recently announced some new features and some new pricing to try and make your service more palatable, I guess, to smaller firm lawyers. You want to just describe, Jake, what you're doing along those lines?
Yeah, absolutely. I mean, again, I think as I mentioned earlier in this conversation, what we're seeing is a lot more attorneys who are already, even without us even necessarily reaching out to them or targeting, right? A lot of our initial sales and marketing was focused on some of the bigger firms where both Pablo and I practiced, and many others here at the company as well, like Laura. We were focused there first, and organically we saw hundreds of smaller firm attorneys sign up, beg us to add a credit card form so they can just please use the CARA functionality, but also everything else: searches, reading documents, sharing PDFs, even some of the copying of citing, copying of parallel paragraph citing, or parenthetical citing, I should say, something that Pablo introduced, which is a really neat feature for those who like to cite their cases in parentheticals. Like all these features, big and small, they said, we love it, we want to sign up. And we realized that we were becoming, for a growing number of attorneys, their complete research solution, and wanted to now be really intentional about that. Make the tool dramatically more affordable so that compared to a single state plan on one of these bigger platforms, the average attorney will save $1,500 or more a year, given our pricing, to get all 50 state and federal law, to get advanced technology like CARA to make them dramatically more effective and efficient at their practice, so they can, if they're on contingency, they don't have to waste time and money trying to win. And if they lose that case, it's all time, money, and effort out the door. We've, as you said, introduced new technology and features besides pricing to make it even more accessible for folks at smaller law firms. It includes the citator, so you can use it as a complete legal research solution. It includes a browsable, full text, updated at least daily database of 50 state statutes and soon regulations. And it includes some specialty content like PTAB for some of our solo and small firm attorneys who are currently working with the Patent, Trademark, and Appeals Board, for example. So it was a huge undertaking by our team to get us to a place where we say, even if you are using us as your sole legal research provider, you will not have to look anywhere else. You have everything you need. And we're trying to, everything you need that we've done, we believe executed on very well. And it's all at a price that is, easily within the range of affordability, usually half as much or less than the alternatives.
Pablo, I've known you long enough now to know that you're always working on the next new thing for Casetext. Is there anything you're working on that you can talk about that hasn't
absolutely.
been officially rolled out yet?
Absolutely, we're working on stuff. And Bob, you always get the private demos. It's a little premature to talk about some of the things, but I think generally in terms of longer term, we're just scratching the surface on what you can do once you have a search engine that actually pays attention to the specific case at hand. And so there's a lot of things that haven't yet been touched by that approach that need to be upgraded for it. And let me just add one thing on the small law one thing, because Bob, you talked about the long-term 5-year and the pivot things. For me, it's been really cool to see, when I first started talking with Jake immediately saw the need for democratizing access to law and for, creating these access to justice. And the truth is, I just wanted to get revenge on all the technology that they made me use when I was practicing, right? And so it's been really actually cool to see now, as we start to do a lot more of these programs and these feature packages that bring to small law offices some of the firepower that normally you would need a few associates to do. I think this sort of gets to what Jake's saying about how different approaches can change, but the underlying sort of theme and narrative and goal is actually more constant than it might seem. I think we're in some ways now reaching the phase where we're going to be doing that a lot in a very real way.
So I already gone over the time I wanted to go over here, but let me just, Jake, you guys last year you had a Series B funding around $12 million, which at the time, from what I saw, was one of the largest investments ever in a legal tech company, at least as of that point. And you'd already had an earlier $7 million Series A. So what's 5 years in? What are you seeing for the next 5 years for Casetext?
I think a few things you can expect from us. First of all, as to the funding, it's not cheap to build a legal research tool. This is not, as you might imagine, it's acquiring every single law in America and then the world is an expensive undertaking. Adding information to it, whether it be through data scientists or through human editors or through crowdsourcing, is a time-consuming undertaking. One of the things that really excites me about where we stand today is that we took that initial investment of money and took a large investment of time and effort to get to a place today where we are a dang good legal research platform that anybody can use and will likely be faster, more efficient, save a lot of money, et cetera, compared to some of the alternatives that have been around for in some shape or form, maybe over 100 years. So we feel very, very, very good about that. In terms of the future, I think a few things that you can expect. I believe that in 5 years from now, people will not legal research without Casetext. That you will not write a brief, write a memo, advise a client without using groundbreaking technology that we are already developed or will develop to get the best answers fast. And to automate some of the most difficult parts of doing legal practice. I imagine a future where whether you're a firm of one person or 1,000 people, technologies like being able to automate a lot of the difficulty in writing a brief and drafting, being able to make very quick or easy finding the right information without inputting that much information, being prompted automatically with new information as it comes out that's highly tailored to what you've been working on, being brought immediately to the right part of a 100-page document. That will all be done through intelligent technology, whether you call it artificial intelligence, legal informatics, or hip hop. That's going to be a really big part of what we do. And
let's go with hip hop from now on.
Yeah, exactly. We got HH technology, I guess. So I think that's one very big part of it. And I think without talking too much about some of our kind of behind the scenes in the labs kind of stuff, it's a little more secret. I do think that the world will continue to as we come out with new technology, we'll continue to be hopefully impressed, but at least we'll find very useful, some of the stuff that takes processes and it takes attorneys 10, 15, 20 hours of rote, terrible, hard work and makes it painless, seamless, quick. So they can, and really at the end of the day, what I hope for is a world where clients who we're all trying to serve at the end of the day, and I'm talking now about the clients of legal services, whether they be Fortune 500 companies or small businesses or individuals, can afford great legal services because the attorneys they're working with are using the best technologies to make themselves efficient, effective, to at the same time improving the information around them to practice law even better, so that you don't have to have high means to get access to really amazing legal services, and so that companies. I saw a statistic once that 30% of Fortune 500 profits are being spent on legal fees and fines, et cetera. I think that across the board, there's so much room for improvement, and I hope we play an important part of that.
And, let's give a shout out to venture capitalists. The marriage of venture capital with this, when I was an undergrad at Berkeley, I was the lowest ranking person on the Human Genome Project. And I literally cleaned up biohazardous spills. And, during the time I was at law school, the cost of sequencing a genome went from $3 billion for the first project to I think now it's a few $100. And during that time, the cost of litigating a patent, I think, stayed about steady at $6 million. And I think one of the things that you were seeing in medicine and other industries is the power of venture capital, the ambition, the speed, the standards, just the entire philosophy that it brings. And I think that it's one of the things I've been what's been so satisfying to see over the last 8 years is how much, when I first sort of arrived at Stanford Codex, I think you could count on one hand the number of legal tech startups. And now you're seeing just a huge number of them getting funding from fantastic investors. And so I encourage any folks listening to this who are in their own garage or living room, like Jake and I were 5 years ago, to really understand that these resources are now out there if you're willing to do the work and to go get them.
Yeah, that's an important point. And it's been interesting to me. I think I first talked to Jake. I first talked to you within 2 months, I think, of your starting the company, and we've had any number of conversations over the years since. So it's been a real. It's been really interesting to follow your trajectory and your growth and your development. And congratulations on 5 years, and best wishes for the next 5 years. Thanks a lot to both of you for taking the time to be on this show today. I really enjoyed talking to you both.
Always fun talking to you, Bob.
Thank you, Bob.
All right. Well, that does it for today's episode of LawNext. If you like what you heard, please go over to Apple Podcasts and leave a nice little review there. And be sure to subscribe to receive future episodes. This is Bob Ambrogi. Thanks for listening.